Everyone, welcome to the appellate court. I'm Judge Bright. I'm sitting this morning with Judge Alexander and Judge Levine on the case of State versus Smith. The AC docket number is 44525. We are conducting this argument over the Teams platform, so everyone is appearing by video and audio. I'm going to ask everyone to introduce themselves so we can make sure we can hear and see each other. I'll start with the judges, then ask the appellant, and then the counsel for the appellee to identify themselves. Again, I'm Judge Bright.
Good morning, Judge Alexander.
Good morning, Judge Levine.
Mr. Smith.
Good morning, Melissa Patterson, Senior Assistant State's Attorney representing the state.
All right, I can see and hear everyone okay. I'm assuming that's true for everyone else. If at any time you are unable to hear anyone or see anyone, please let us know. If anyone gets disconnected, we will pause the argument until we get everyone reconnected. I will keep the time during the argument. Each side will have 20 minutes to argue. The appellant can reserve some time for rebuttal. I will hold up signs at 2 minutes, at 1 minute, and when time is up, to let you know where you are in the process. With that, I think we're ready to proceed. Mr. Smith, are you ready to go? Just before you start your argument, identify yourself and let me know how much time you'd like to save for rebuttal.
Mr. Smith, pro se litigant, and I figure about only need 8 minutes in the beginning. I'll preserve the rest.
Okay, go ahead.
All right, I just wanted to start by saying that the court appears to have, throughout this entire matter, evaded the whole reason for my being here, because and distorted the narrative by way of stating that my double jeopardy claim is other than what it started out as. Hold on, probably before I get into that, let me start by saying that there were structural errors that were brought into this case by way of the state or the trial court utilizing information from a trial that was other than my own in its initial trial court decision, the one dated back in 2016. And as such, that information has been utilized as facts by the state in its brief, as far as the counter statement of the issues and whatever. They keep saying the facts underlying the crimes when these facts aren't facts at all, because it was things that didn't happen in my trial. Like, for instance, on pages 3 to 4 of the trial court's initial decision, the trial court stated that at trial, the state called several witnesses who solidified the case against the defendant, and then provided trial testimony of a Liz Metcalf and Amanda Blackman, who didn't testify at my trial. They testified against the trial of a co-defendant, but they went on page 4 to say that the defendant lived at Michael Road. My co-defendant lived at Michael Road. Also on page 4, they said the defendant then stated Mr. Pierre made 2 statements. After saying that, they provided 2 comments made by Mr. Pierre and intimated as if I made those comments. Also on page 4, it said Jarvis with Britton and Smith drove to the defendant's house. Also on page 4, it said Britton and Smith walked over to the victim's car, which contained the victim and the defendant. On page 7, it states the defendant's convictions were final in 2006. Right after that, it states that the appellate court affirmed the defendant's convictions and sentences in this matter in 2008. Clearly, they were talking about my co-defendant, and now the state's been utilizing all that information and putting it in as facts. And I fear that moving forward, any subsequent court may take those facts and try to use them against me, especially in light of the fact that the state said, the trial court stated, the state called several witnesses who solidified the case against the defendant.
Mr. Smith, I can assure you that the underlying facts relating to the conviction, whether they are accurately stated by the state or not, are not relevant to our consideration of the motion to correct an illegal sentence.
Yeah, go ahead.
So what we're interested in is what your claim is as to why your sentence is illegal putting aside any facts that underlie the conviction, whether they're accurately or stated or not, we can't touch the underlying convictions. We're dealing solely with your argument as to why your sentences are illegal. So can you address that for us?
But the trial court is distorting and misleading the subsequent courts by stating unnecessary stuff. They claim that on page 1 of the trial court 2016 decision, it states the defendant claims his sentence was illegal because the manslaughter was merged with the felony murder. I never claimed that. I claimed that my sentences were illegal due to the fact that I was twice placed in jeopardy for the same offense.
Okay, could you explain that argument to us?
Okay, and stating that the twice placed in jeopardy for the same offense. I'm stating the fact that in State v. Kennebrew, this court noted how the protection of the state constitution provides against double jeopardy is coextensive with that provided by the Constitution of the United States. And in State versus Adams, this court concluded an alleged double jeopardy violation to be a proper basis for a motion to correct. Yet when I alleged that my constitutional double jeopardy right not to be twice placed in jeopardy for the same offense was violated, pointing out the many existing double violations arising from that violation, the state and the trial court ignored my allegation and or argued that such a claim is a collateral attack on the underlying conviction, saying that the trial court lacks jurisdiction to hear that. I've alleged a double jeopardy violation saying that I shouldn't, by placing me twice in jeopardy, that's the violation I'm alleging. The state
can you explain that to us, at least to me, help me understand where you claim that you were placed in jeopardy twice for the same conduct?
By way of the state, I was charged with capital felony murder, and felony murder against one individual. That's in separate counts. By way of those separate counts, that's where the triple jeopardy came in for the murder.
But you were convicted of one of those, correct?
Exactly, but the jeopardy stems from being placed in jeopardy. As noted in United States versus Ball, 163 U.S. at 662. The United States Supreme Court stated that the prohibition against double jeopardy is not against being twice punished, but against being twice put in jeopardy for the same offense. And by placing me in jeopardy for those same offenses, multiple subsequent violations stem therefrom, such as cumulative convictions and whatnot. And the state would rather address the cumulative convictions than the fact that I was put in jeopardy twice. I'm stating that the twice put in jeopardy portion is where my argument stands due to the fact that I was acquitted outright for one homicide offense, but yet here I sit for the same homicide offense. How can I be acquitted for homicide yet found guilty of the same homicide without being twice put in jeopardy for homicide? That's where my double jeopardy argument stands, and it's the failure to honor the full protections of the double jeopardy clause, which vitiates the limited purpose of 43-22 and unrealistically expands the court's jurisdiction beyond its common law bounds, endorsing the sort of governmental oppression of the sort against which the double jeopardy clause was intended to protect. You keep placing you place me in jeopardy and then try to backdoor it and clean it up and say, oh no, we can remedy it this way. You can't remedy it if you've already placed me in jeopardy. And
so as I understand your argument is because you were charged with multiple homicide offenses for one homicide, just the charging itself is your argument you were placed in double jeopardy. Or according to the United States Constitution, but it's not just so much the charging, it's the fact that I was acquitted. So standing on the acquittal, if you were to take me to trial separately and say, okay, you charged me with capital felony murder, could you then, after a not guilty verdict, say, you know what, we're going to rearrest you and charge you again? So you're trying to skirt the protections of the double jeopardy clause by charging me all at once.
and then charge me all at once. You're violating the double jeopardy clause, the crux of the double jeopardy clause. That's my argument, and the state continues to, try to circumvent the clause by saying, "Oh no, because it was one trial, we get to." How do you get to do that? Especially in light of the fact that in State versus John, it says homicides are to be treated as a single crime for double jeopardy purposes. How can they be treated as a single crime if I was acquitted and then found guilty of the same crime? That's not treating them as the same crime. You're allowing pretty much a re-prosecution of sorts because the acquittal should have been final as to the homicidal aspect. However, you're telling the jury, "Oh, no, well, consider it this way." Well, how are you giving the state a second bite at the homicidal apple without violating my double jeopardy right?
You've gone past your 8 minutes. You can keep going if you want, or you can stop.
I just wanted to see where the state was at with that, and then we can pick up from there. I'll try to respond to whatever the state.
All right, so you'll have 10.5 minutes left. Okay.
Thank you.
All right, we'll hear from the state.
Good morning again, Your Honors. Melissa Patterson, Senior Assistant State's Attorney representing the state of Connecticut. Based on the court's questioning, I would like to address the first issue, sub-issue C, that I've addressed on page 29 of my brief. To the extent that the defendant is claiming that there was an issue with the charging, it appears that that is not what he was claiming before the motion to correct court. But to the extent that such an argument is being raised here, that's not a challenge to the sentence. It's a challenge to the charging. And so by way of extension to the convictions. So there's no jurisdiction to address that claim on appeal and in a motion to correct proceeding. To the extent that the defendant is pursuing this, quote unquote, as I've termed it, a subsequent prosecution claim, there is also no jurisdiction for that. And to the extent that I have described his claim correctly, there is no jurisdiction because this idea of an acquittal after, a conviction after an acquittal, the context that he's talking about is in multiple trials. Here, the state was permitted to charge various forms of homicide. It was able to proceed on that at trial, have the jury return a verdict. The jury was permitted to acquit on some and convict on others. When it came down to imposing sentence, and at that point, the trial court merged the manslaughter charge and imposed sentence only on the felony murder charge. I want to address the defendant's claims, but I am not sure how to address it in any other form than saying that is a permissible way to conduct trial and to impose sentence. There is no error in that. It's consistent with the law. There is no jurisdiction to address that claim, though, because it's not truly a double jeopardy claim, because there are no multiple trials. I am happy to flesh that out more for the court. I am not entirely sure how to discuss it in a way that isn't sort of regurgitating my brief, regurgitating what I just said. So that's the only issue that the defendant has addressed in his opening. I, though, am happy to discuss or answer any questions for the court having to do with that first issue or the other two claims that I've addressed in my brief.
Attorney Patterson, I just had one question for you. On the merger aspect of merging the manslaughter into the felony murder, you said it was appropriate for the court to do that. Is it the state's position that the court it's the court's option whether it wants to sentence on the manslaughter versus the felony murder? That it doesn't, because they're not one's not a lesser included offense of another, it's not necessary that the court sentence on the more serious charge?
No, Your Honor. While imposing sentence and determining the type of sentence, the court has discretion in that regard. The court would not have had discretion in this case where you have a felony murder, which is the Class A, and it has the the legislature has deemed a larger max minimum for that particular sentence, that the trial court would not have had discretion to vacate or merge the felony murder in favor of the manslaughter and sentence only on the manslaughter.
Okay, thank you. Judge Levine?
Quick question, Attorney Patterson, when you said no jurisdiction, as you just argued, just to be clear on that, are you arguing that the trial court lacks jurisdiction to consider the argument that is being put forth because it does not relate to the sentencing, but rather to the charging? Or are you saying this court lacks jurisdiction, or both? Could you clarify what you mean?
So the defendant's first issue involves the felony murder charge and conviction and the manslaughter. To a certain extent, perhaps, if one were to parse out his claim and parse it out to the felony murder and the manslaughter, assuming we're not looking at the manslaughter and just the felony murder, essentially, I would rely on State versus Evans and the other Supreme Court cases that talk about that describe jurisdiction for purposes of a motion to correct. And I would assert that there's no jurisdiction because it's not a colorable claim. There must be to the extent that one raises a claim that there's a double jeopardy violation because I was convicted after an acquittal. That claim itself, there perhaps is jurisdiction in a general sense, but based on both the legal claim and the factual circumstances of this case, which Evans says must be considered, there is no jurisdiction because there were no multiple trials in this case. So that's why there's no jurisdiction.
In the trial court?
Correct. Before the motion to correct court, there was no jurisdiction to decide that claim.
Right. And therefore, we also lack jurisdiction review, or not?
Correct. So what would happen is we've asked this court to remand to the motion to correct court to dismiss just that portion of the motion to correct because the trial court had no jurisdiction to decide that claim.
Okay, thank you.
Your Honors, as I mentioned, I'm happy to answer any remaining questions. I believe I have addressed all of the defendant's issues in my brief. To the extent there are no questions, I would rely on my brief for the remaining and ask that this court remand with an order to dismiss part of the motion to correct and affirm the denial in part with regard to the second issue. Thank you, Your Honors.
Okay, thank you, Attorney Patterson. Smith, you'll have 10.5 minutes.
All right. The alleged double jeopardy violation that I speak of speaks directly to the acquittals, which in turn challenge the validity of the sentences themselves, given their attachment to what the state Supreme Court referred to in State v. Miranda as unconstitutional, unauthorized, and unlawful. So if I'm being sentenced to convictions that have been deemed unauthorized, unconstitutional, and or unlawful, how can I not challenge them in a motion to correct when the whole thing is to correct sentences that are considered illegal and or unconstitutional and unlawful?
So, Mr. Smith, can I just ask you a question? Because I want to make sure that I understand all of your claims. The state addressed two other claims. One was a claim that that just because that there was no double jeopardy issue relating to the kidnapping and robbery convictions and being sentenced on those in addition to the felony murder. Are you making a claim relating to those convictions?
Yeah, relating to those convictions, my argument goes to is supported by this state's rulings in well, not this court, but the Supreme Court ruling in Greco and State versus Miranda, I believe. Because in Greco, the state, there was in Greco, the reason I bring up the double jeopardy as far as the felony murder and the charge of felony murder alongside the actual underlying felonies is because at the end of Greco, it stated that issue raises problems of multiplicity and notice that are best left to another time when we are presented with the information not plainly alleging separate and distinct offenses. They didn't allege separate and distinct offenses. You charged me with felony murder, and then you used the same felony and charged me with in a separate count for those felonies as far as the kidnapping and the robbery. Now, without kidnapping and robbery, you wouldn't have felony murder. So if you're saying felony murder requires you to give me 60 years, that's only because of the felonies that were included. Now, charging me with the felonies on top of that and then sentencing me to those felonies oversteps the boundaries because now I'm getting 60 years due to the fact that these felonies were equated with a felony murder. And then I'm getting 25 more years or 20 more years for the actual felonies themselves. This is another double jeopardy issue, which in Greco says it needs to be challenged. Just like in Miranda, the same thing came up in State versus Miranda. They said that, what was it? The defendant did not allege in State versus Miranda a challenge to his extra kidnapping, the being charged for kidnapping. So the Supreme Court seems aware that there is a what's name, but nobody's bringing these challenges to the court. And for the state to sit here and say that, oh well, there's no precedent. There might not be no precedent here in Connecticut, but federally, everything that you just spoke on as being legitimate is the state's whole brief is relying on state cases. My brief is relying on federal law. It says that Connecticut is supposed the double jeopardy protections mirror that of the Constitution. The Constitution says I should not be put twice in jeopardy because of double jeopardy provides that no person shall be twice placed in jeopardy for the same offense. Here in Connecticut, you're ignoring that part of the Constitution and saying we can place you twice in jeopardy and we can have inconsistent verdicts and still sentence you to these crimes and there's no problem. Well, there's no problem because nobody's ever challenged it, which is why there's no case law on this here in the state.
Mr. Smith, can I ask you, when you say there's no case law in the state, in your last motion to correct an illegal sentence, which was decided by this court, and then the Supreme Court on appeal addressed one particular issue. Didn't this court already address this issue of the kidnapping and robbery charges, whether that was double jeopardy as to the felony murder charge?
I submit that the prior rulings in this entire matter are pretty much erroneous based on the fact that, for one, the trial court initially denied the motion. After denying the motion, the trial court went on to rule on the merits. And in State versus Benjamin Cruz, this court said opining on the merits after the matter was denied was unnecessary, and that portion of a decision cannot provide a basis on which to affirm a judgment. This court then affirmed that judgment based on the erroneous opining by the trial court. The trial court came right out and said, we denied a motion based on retroactivity principles. Later on, the trial court, again, we denied a motion based on retroactivity principles. The trial court, after denying a motion twice, then opined on the merits erroneously. After opining on the merits erroneously, this court came in and affirmed the trial court decision by accepting that erroneous opining as fact. But in State versus Benjamin Cruz, Appellate Court 36420, a 2015 case, it says that that's not proper. So,
okay, I understand your argument with that, and I have one other question for you. Are you making a claim that the court was required to sentence you on the manslaughter charge instead of the felony murder charge?
If after considering the double jeopardy argument that I made with regard to being twice placed in jeopardy, if after considering that, we move past that. You consider that that's not an option. Okay, now on the felony murder, pursuant to like Judge Levine just said, for the court to be able to choose which what's his name is it gets the sentence on, that in and of itself, according to federal law, is not consistent, because in United States versus Ball, or Ball versus United States 470 U.S., it stated the second conviction is impermissible. So if the second conviction is impermissible, how do I get convicted of felony murder first? Of manslaughter first, then I get convicted of felony murder, and you ignore the manslaughter in favor of the second conviction, which by federal standards is impermissible.
So is your argument that if the judge had asked the jury to decide the verdicts in a different order, the outcome would be different? If the court had said to the jury, first determine whether the defendant is guilty of felony murder, and then determine whether he's guilty of murder and manslaughter, your argument would be different.
See, that this is where the boundaries of emotional correct go astray, because now we're looking at, okay, we're talking about not inconsistent verdicts, but the two convictions, when two convictions are counterintuitive to one another, because murder is considered intentional, felony murder is considered unintentional. So now you're putting on the track. This is, like I said, now we're getting outside the bounds of emotional correct, because now we're calling into question the veracity of the verdicts themselves, which, for one, there shouldn't be none. But to sit here and say that we have mutually exclusive verdicts, mutually exclusive charges, that in and of itself, now, like I said, we're getting way beyond the emotional correct, when clearly it says I can bring a double jeopardy claim. I tried to bring a double jeopardy claim. The state is trying to, for some reason, say that isn't double jeopardy, and that has nothing to do with double jeopardy, when in fact that's all double jeopardy is about federally. It begins with the putting up a person in jeopardy for the same offense. That's where double jeopardy begins, and anything after that it's a different sort of double jeopardy. But you're saying because it was one trial, that's permissible. But you're not citing any case law. You're just saying whatever you say. I'm showing you federally where they say you shouldn't be doing that. But because in the state, nobody has yet to challenge it, just like with the whole Miranda and Polanco thing. Nobody challenged that for years. Polanco suddenly challenged. You've been doing it since State versus Chicano in 1990. Miranda finally challenged it, and Polanco challenged it in 2013. Now all of a sudden, we see we were wrong. Okay, well, I'm bringing the challenge saying that we've been doing things wrong here in the state of Connecticut for a while now. Somebody needs to look into this. Granted, I'm not trying to go beyond the scope of emotional correct, but when you say that I can bring a double jeopardy claim, now it appears that you're limiting the type of double jeopardy claims I can bring. And like I said, going back to if you were to look at the previous brief in this matter, as well as the current brief, even go back to the Supreme Court, where the state Supreme Court, where one of the judges, I believe on page 25 or something like that, he noted that, listen, Mr. Smith is bringing a double jeopardy claim. So for the state to continue to ignore my double jeopardy claim, when one of the justices from the Supreme Court, I believe it was Justice Ecker, he said, yeah, he's right. There is a double jeopardy claim here, and we shouldn't continue to bury our heads in the sand and act as though he didn't bring that. So, like I said, I'm just trying to figure out what's what. The trial court, like I said, never addressed the fact of being twice put in jeopardy. That was always given short shrift by the state, saying, oh, this is erroneous, and or Mr. Smith doesn't understand, he can be charged with whatever, but you're not citing any case law. It's just basically the trial court's opinion. And here it is, the prosecutor now, the state is basically doing the same. You're standing on pure state case law, when in fact I'm showing you federally what you're doing is wrong. Okay.
All right. Thank you very much. We will take the matter under advisement. We will stand in recess while we go to the courtroom for our next case.
All right. If you look at like I said, the previous judgments with that.
We'll look at all of that, Mr. Smith. We'll look at all the judgments, the case law, and what the Supreme Court said in the prior appeal. Thank you.
Thank you. Thank you. Have a good day.
You too.
No, it's always the last one. It's always the last one. That's what it was.